If you're one of those people who does a lot of your booking for travel online by yourself, and I think it's fair to say more and more people are actually doing that, he said, looking at himself in the mirror, this next story is a very cautionary tale, especially when you think, you know what, you're getting really good at this, and maybe you have a leg up. Well, let's find out more. David Feuer is a digital rights lawyer and director of the Samuelson-Glushko Canadian Internet Policy and Public Interest Clinic at the University of Ottawa, and he is on the line. First of all, Mr. Feuer, I do appreciate your time this afternoon. And as I said, and I wonder if you agree, I think we can acknowledge more and more people are going ahead and booking travel online themselves. And typically, you know, it's a pretty straightforward process. But the story we want to deal with today has been anything but. So I'll just start off by doing the setup here, and maybe you can fill in the blanks. Woman goes online. She wants to come to Montreal to watch the Canadian Grand Prix and planned so far ahead that she actually, because we didn't know the dates before, you know, a certain amount of time, books well ahead, figuring she'll protect herself, and then makes a couple of reservations, cancels one out, and then the bottom line in this story is what price she thought she would pay because she had booked it online turns out to have not been that price. So can you fill in some blanks from there? What happened here?
Yeah, the story is that she booked it through Booking.com, right? One of the online, basically brokers. And the terms of use of sites like that always allow some wiggle room in the event of mistakes. And that's what the hotel that she booked through says happened here, that she got a rate that was a mistake. It was a technical mistake, they claim, not simply that they didn't realize how much money they could make, that they actually had some kind of technical error, and so the wrong price was listed. And so they relied upon kind of the terms of use of Booking.com to retract the deal that she got and offer her, let's call it, the deal that they would have preferred to have had it with her.
Now, I mentioned this is a special event. This was Grand Prix, and you can't help but look at this story and think what happened here was when the dates were confirmed and people started booking, all of a sudden this hotel had decided, hey, we can make, I know you said this is not their argument, but they could have made a whole lot more money. And in fact, the story suggested a room that she had booked for a couple of $1,000s, they were offering it to her, same room, same time, but, oh, I'm sorry, it'll now cost you $17,000. I mean, that's not even close to a mistake. So my question, I guess, is twofold. First of all, with respect to terms and conditions, I'm pretty sure we can all agree nobody reads those, right? At the end of your booking, whatever site it's on, whether it's Booking.com or Expedia or anything else, how frequently does this happen, or do you see this happen?
Well, yeah, I mean, it does happen pretty frequently. Like contract law is not consumer protection law. They're kind of different things. Contract law basically assumes that we all agree to the deals that we sign up to voluntarily, and that includes the fine print. And if the fine print includes these kind of get out of a bad deal clause, that the other side can rely on, well, then you're going to be bound to that. And that's what the hotel is claiming, right? So the hotel is claiming that this was a mistake. It was a technical mistake, and therefore they could get out of it. And that's what Booking.com was trying to enforce. Instead, we have to rely upon consumer protection laws, either laws enforced by the Competition Bureau or by provincial consumer protection authorities that target unfair or unconscionable practices and say consumers have protections against those.
Okay, but again, I'm looking at the story. So the woman in question here booked 2 rooms on 2 different weekends, but each with free cancellation, okay? My question then becomes, with respect to who's at fault here, is it just a matter of Booking.com saying, look, in our terms and conditions, say sometimes things change and they're basically off the hook? Or what about the hotel in question here? Are they liable?
Yeah, no, it's not a question of liability. It's a question of, are they bound by the deal that she thought she'd agreed to? And I guess to the extent that there's any fault, it's that the consumer didn't understand that the deal that she agreed to included this escape clause, right? This technical error clause. And the hotel, they are claiming that it was a technical problem, that they should have had event pricing in place for that day, and it was a technical reason why the event pricing didn't attach to the particular rooms that she had. And so that's what they're using as an excuse. It does sound very fishy, right? It sounds very convenient, and it certainly sounds unfair. But the real question is, could the hotel back out? Could Booking.com cancel the deal under the terms of the agreement she signed? And technically, they could. And that's what's so unfair about the process.
Well, so let's say for someone else who finds himself in a similar situation, I mean, what recourse do you have if that's the case? If they say it's a technical area, are you basically done? You talked about consumer advocacy laws here, protection. Do you have any protection here?
Well, you don't have a lot. You can certainly challenge the perspective, right? Like, you can challenge the claim that this is a technical error. Usually, we say that technical errors are the kind of things where you've got the decimal in the wrong place. You've got an incredible deal for $1. Those are the kind of technical errors I think this kind of clause is supposed to catch. And this technical error looks an awful lot like somebody didn't realize that event pricing should have been in place, ahead of time. That's kind of what it feels like. Unfortunately, there's not a lot you can do to protect yourself against it's what almost comes down to a he said, she said thing. And in fact, this particular consumer, her best defense turned out to be just going public and getting the attention of the media on this and calling out the hotel for its behavior.
So that's
what ultimately got her the deal that she agreed to.
By going public, and then, of course, we know she ended up getting the room for the price she wanted to. I'm just wondering, though, even with the proof that you might have, you have your agreement, you print it out, it's on paper, you have free cancel. None of that matters at the end of this because they can simply use that idea of it being a technical glitch and just walk away.
Yeah, no, it's not the idea that it's a technical glitch, right? It's the idea that this is covered by a term of the agreement. There's an agreement that says if there's a mistake that, we can change that price, we can fix the error. And their position is that this was a mistake, and that's why they can rely upon the agreement. So it's not that they can get out of the agreement. What they're saying is they can enforce the agreement that they had. Mm-hmm. So we've got a mistaken price, so we're going to enforce the actual price. Not enforce, but put in place the actual price, and then the consumer does have the power to walk away at that point. But that's the problem, right? The consumer didn't want to walk away. The consumer wanted the deal that she thought she'd agreed to, and that most of us would have said that she should have had.
My question ordinarily would be, what's the advice to consumers going forward other than make sure you read all the terms and agreements?
Well, what you can do here is, it's not realistic to say. It's just not realistic to say that consumers have to read all the terms and conditions of every contract they enter into, because we are constantly entering into these. There's not enough time in the day to read all the terms and conditions of all the agreements we enter into, not to mention how frequently these things get updated. So, you might think you have an agreement with Google for Gmail, for example, but you know what? They've changed it today. They'll change it in 3 days from now. We just don't have time in our lives to do this. So really, it's more practical things. So when you get a deal, take a screenshot, print it out so that you've got that proof. When you've got, when it gets changed on you in this way, you call the hotel directly and you negotiate, with the hotel to say, this just isn't fair. This is not the deal that we had. Do I have to go public to do this? And if it's still not working for you, you then going public and calling out the hotel might be your best solution.
All right. I guess we'll leave it at that. As I said, be wary if you're going ahead and booking stuff, heading away for Christmas vacation, booking a hotel. You're suggesting these kinds of things. This is not a unique case, right? You're saying you've seen this happen before.
Yes, yeah.
We'll leave it at that.
Unfortunately common.
All right. I thank you so much for your time. Really appreciate it.
My pleasure.
Unmistakably Canadian.
It's the music that raised you.
The artists raising the bar.
Hi, this is Brian Adams.
Hey, my name's Brett Emmons. I'm from the Glorious Sons.
Hi, I'm Nelly Furtado.
Made in Canada. The station that champions Canadian music.
Loud, proud, and all yours.
No passports required. Just press play.
Tap into Made in Canada now on iHeartRadio.ca
or the free iHeartRadio app.